Good afternoon, fellow conservatives. It's my pleasure to introduce to you Joe Burns on a very important topic, recent changes in New York State election law. Joe was born and raised in Syracuse, New York, received his undergraduate degree from Syracuse University and his law degree from Albany State College, or Albany Law School. Shortly after graduating from law school in 2004, Joe began working on the staff of New York State Senator John DeFrancisco. In 2009, he was appointed to be the Deputy Director of Elections Operation of the New York State Board of Elections. Since leaving the Board of Elections in 2015, Joe has had the opportunity to provide legal representation to a number of candidates and party committees across New York State, including the New York State GOP Chairman and former Erie County GOP Chairman, Nick Langworthy. Since 2015, we've had the pleasure to have Joe reside in Erie County in Amherst, New York. I'm proud to say that Joe is my friend and a friend of the Conservative Party. In our recent Fusion lawsuit, Joe has been a tremendous resource to us in going through that lawsuit. So, Joe Burns.
Thank you, Ralph. There's one thing I think Ralph missed in reading my introduction, and that is that I believe I'm the only speaker you'll have these 2 days that's actually done stand-up comedy. That's true. That's absolutely true. Unfortunately, there's nothing funny about what I'll be speaking about. The title of my talk is The Good, the Bad, and the Ugly, Recent Changes in New York State Election Law. I have plenty of ugly to talk about, an awful lot of bad to talk about. Unfortunately, I don't think I have anything good to talk about. So I want to start out by discussing the actual changes to the election law that were made by the state legislature. Follow that up with some discussion of a few cases that I think you'd all find interesting and probably important for your committees and your candidates. Third, Ralph mentioned the Public Finance Commission. I'm hoping I can discuss a little of what that commission's product is. And finally, a little discussion on what's in store in the future from our friends in the state legislature. So, first off, and hopefully we'll have time for some questions. First off, some changes that the legislature made to the election law. Some of these, I would say, are neutrals, but for the most part, I would say these things are pretty awful from somewhat from a right-of-center perspective. First of all, pre-registration for 16-year-olds. Previously, 17-year-olds could pre-register. When they become 18, their registrations would take effect, and they, of course, could vote. Legislature changed the law this year to allow the same process for 16-year-olds. So I think that's probably high school juniors can now pre-register. Number two, absentee ballots in county committee primaries. Some of you might not be aware that previously the election law did not require absentee ballots to be provided in primaries for county committee races. There's one exception to that, and that was Albany County, which lost a federal lawsuit some years ago. The court said that they were required to provide absentee ballots for county committee primaries. The idea, I believe, was that because the county committee reorganization took place in such a short period of time after the primaries, there wouldn't be enough time to actually canvass the absentee ballots. Well, the legislature changed the law in 2019, so now every county is required to provide absentee ballots to those who request them for county committee primaries. Uniform primary voting hours. For those of you from downstate, you're probably aware that, and from Erie County, you're probably aware that on primary day, the hours the polls are open are from 6 a.m. to 9 p.m., just like the general election day. For the vast majority of upstate, the primary day hours had been noon to 9 p.m. This change was made last year so that now for primary elections across the state, regardless of what county you're in, the hours are 6 a.m. to 9 p.m. Opportunity to balance, probably something everyone here worries about from time to time. The legislature changed the election law so that now members of the committee to receive notices for an opportunity to ballot petition must file an acceptance. That's something to be mindful of. I'm guessing the folks here are mostly worried about defending against opportunity to ballot. Something to keep an eye on, that your opponents, those who are trying to steal your line, the conservative line for their candidates, their committee to receive notices is now going to be required to file acceptances. Something to be mindful of, something to be aware of. One more trick, if you will, that could potentially validate somebody's petition. In addition, regarding opportunity to ballot petitions, there's been a slight bit of confusion in the past as to who stands in the place of the candidate for an OTB petition. And the legislature cleared that up. It's a state that it is the committee to receive notices. They do act as the candidate in an opportunity to ballot petition. It's important when you get into court, you know who has standing, who your defendants are, or who could initiate the lawsuit. If you recall from a few years ago, I believe it was Rob Astorino, when he ran for governor, circulated an independent nominating petition for the Stop Common Core line. After that qualified, the Stop Common Core party changed its name to the Reform Party. Well, the legislature changed the election law this past year to prohibit parties after they qualified from changing their names. From what I understand, there's no law in the country that is close to this. Whether it would survive a constitutional challenge remains to be seen. But again, something to be mindful of in the future, that the newly qualified parties are prohibited from changing their names. For some of you that aren't from a bigger county like Erie County, you probably frequently deal with candidates who are raising or spending less than $1,000 in their campaign. And there had been previously an exception in the election law that allowed candidates who didn't raise or spend more than $1,000 for the campaign to not file. Well, that was changed as well. So whether you're spending $100,000 on your race or whether you're spending $150 on your race, you are required to make all the filings with the State Board of Elections. Again, it's for someone like Ralph or I, coming from a bigger county in Erie County, a bigger county like Erie County, there aren't many races, there aren't many competitive races where candidates are spending less than $1,000. But for some of you from the smaller counties, you might be dealing with a small town supervisor race or a small town board race. That's something to be mindful of, that you now have to file even if you spend less than $1,000 in your race. Attribution requirements. Previously, printed materials in New York State, for instance, your candidate palm card wasn't required to have an attribution paid for by Citizens for Joe, paid for by People for Good Government. The legislature, this took effect January 1st of this year, legislature imposed an attribution requirement on all printed materials for candidates or committees for that matter in New York State. And this doesn't just apply to printed materials like palm cards or mail. The attribution requirement also is applied to television, radio, or digital forms of communications. There are some exceptions. Promotional items, so maybe a nail file or a bumper sticker. Promotional items are not required to have the paid-for-by attribution. When it comes to digital media, I suppose an ad on Facebook or an ad on the internet, digital media, there is an exception where there isn't a requirement for the paid-for-by attribution. However, the ad, if it doesn't have an attribution, has to be linked to a website that would provide that paid-for-by attribution. That's a pretty big change, and I'm sure many of you have put out mail, designed palm cards that didn't state who paid for the material. It's a pretty big change, and I wouldn't want to be the one who didn't put that on your material and got called on. A more mundane change, but not insignificant. For two-sided ballots, I'm sure you've all voted on a two-sided paper ballot at one time or another with candidates on one side and maybe a proposition or two on the other side. And we know the old story that people forget to vote for those propositions. They're only in to vote for the candidates. Well, from now on, the ballots that are two-sided are required to have an arrow showing voters that they have the opportunity to vote on propositions on the opposite side of the ballot. This next one I know is going to be pretty important for the folks in this room. The new requirements for a change of party enrollment. Previously, I think this was the case, New York had the longest period of time that you had to wait after you changed your party enrollment. Previously, it was 30 days before a general election, and then it would take effect after that general election. There was actually a case, I think, from the 60s or 70s that went all the way to the U.S. Supreme Court on this issue, and the court said it's perfectly fine as a way to keep party raiders out and defend the integrity of a political party. Well, now you can change your party enrollment up to the 14th of February. It's Valentine's Day. And it will take effect immediately for that year's June primary election. If you change your party enrollment after the 14th, it will take effect 7 days after the June primary. For folks in the minor party, the Conservative Party, I would say you have to probably, in light of this, you've got to redouble your efforts to make sure that you aren't the victims of party raiding. The legislature has just made it a lot easier for outsiders to come in and influence the outcome of your primary elections, your committee elections. And I know at one point or another, I put the bug in Ralph's ear, I mentioned it to Ralph. In light of this change, in light of the fact that it's a heck of a lot easier now to invade someone else's political party, especially the Conservative Party, everyone ought to take a look at Article 16 of the election law. I forget the section off the top of my head, but you ought to take a look at Article 16 of the election law and see that there is an opportunity to prevent people from raiding your party. In fact, to bring them up on charges and take them to court and throw them out of your party. It's called disenrollment. And it's something that I think everybody, especially in this room, ought to take a look at because it's a tool that's out there. It's cumbersome. It's not the easiest process, but it is something, it is a tool that you have in your arsenal to defend against party raiding, which again, thanks to the legislature, has just become a heck of a lot easier. You probably heard the other side over the years talking about what they call the LLC loophole, what I like to call the so-called LLC loophole. When they had their opportunity in early 2019, they took their opportunity to close this so-called LLC loophole. What was it? Well, in the past, an LLC, that's a limited liability company, could give in the same manner that an individual could give. So if Joe Burns could give $1,000 to John Doe for Erie County Legislature, then XYZ LLC could also give $1,000. And if Joe Burns could max out to every Republican candidate for the state assembly, then XYZ LLC could do the same thing. The LLC's game is if they were individuals under individual limits. After January 31st, 2019, that's when this the LLC loophole closure took effect. Now, LLCs are limited to giving no more than $5,000 to all candidates, at exclusion of party's housekeeping account. $5,000 to all candidates in a calendar year. That's similar, you might be aware, to the corporate limit. Corporations were limited to giving, have been limited to giving $5,000 to all candidates in a calendar year, with the exception of a party housekeeping committee. In addition to this new limit imposed on the LLCs, there's now an attribution requirement. So an LLC has two owners, and that LLC gives $5,000 to a candidate for governor. Those two owners each own 50% of the LLC. Well, $2,500 will be attributed to each of those individuals off of their individual limit for that candidate for governor. It's made things, from what I understand from people I know, donors who have given through LLCs, it's made things a heck of a lot more complicated for them. And I know some folks from different businesses have now decided that they're only going to give us individuals, or their company is going to form a PAC, and owners or directors will contribute to that PAC. In addition, I should also add that there is an additional disclosure requirement for LLCs that contribute, where they have to provide their ownership and the breakdown to the State Board of Elections annually by December 31st. I don't know what I would recommend if you have given through an LLC in the past, but it should be something that you're aware of, and there might be better ways for you to make your political contributions and be active politically. One of the big changes from last year that I'm sure you're all very much aware of was the change in the primary date. We went from having the federal primary in June and a state primary in September to a unified federal and state primary in June. As you also know, the presidential primary is the 28th of April this year. Another change, because of the primary date change, the judicial conventions are now in early August instead of mid to late September. I don't know the dates off the top of my head, but if you check out the State Board of Elections website, they do have the political calendar with all the significant dates. One change that I'm sure the folks here will be very interested in is the new date, I shouldn't say new, the dates for the county and state committee reorganizations. Well, so much else has changed, like the primary date, the judicial conventions. The dates for the county and state committee reorganizations have remained the same. So you're electing your state committee members, your county committee members in June, but they won't be reorganizing your committees until September and October, as had happened in the past. Something the folks here should definitely be aware of for when you do your own county committee reorganizations. A little odd that we now have committees that are still in effect, still have power, with a newly elected committee that really doesn't have anything to do for some number of months. Certainly a big change. If you're here. In It took effect, as I'm sure you're aware, for the general election 2019. In the future, we will have it for every primary, special, and general election. Hopefully, when I get to what's coming next, what's coming soon, some legislators have already been making proposals on how to tinker with early voting, things that I'm sure no one here will be happy about, but they're already at it. They're already looking at making what they would call, I'm sure, improvements. Those are the big changes in the statute that were made over the past year. If I can now, I'll mention a few of the cases that I think the folks here might be interested in as applies to your committee, as applies to your candidates. I'm happy to say I was involved in a couple of these. Unfortunately, I was at a losing end of them, but nonetheless, they're important. First, the case of Vaca versus Kaczynski went to the 3rd Department, involved the 7th Judicial District Democratic Nominating Convention. This was one of them that I was involved with, and unfortunately, we wound up on the losing end. The Democratic Committee did something that I'm sure no one here would ever do. They filed their judicial convention minutes late. We thought that this would be more than enough to invalidate their convention and cause them to lose their candidates. Unfortunately, the Supreme Court judge and the appellate division thought differently. The Democratic Committee provided an excuse. I didn't think it was a very good one. They were holding their vote for the new election commissioner at the same time at the same location. And the court said, and they claimed that that's what caused the confusion, and that's what caused the late filing of their minutes. The court said that that was perfectly fine, that it was a good enough excuse, and they were only minutes, they weren't the nomination, so it wasn't that big of a deal. My suggestion to the folks here, and even though we have this decision on the books, don't file your judicial convention minutes late. There's no reason to not get it right the first time. But if in the odd event that you do file them late, think of a really good excuse, because the courts are liable to lie. This case I was not involved in, Hennessy versus Oneida County Board of Elections. This went to the 4th Department. Probably something that the folks from here from New York City have been involved with in the past. A lot of apartments, a lot of big apartment buildings there. The signers for one candidate's petition listed their street address, which was an apartment building, but not the apartment number. The appellate division said that's perfectly fine. The street address is sufficient. You don't need the apartment number. So if you reside at 123 Huckleberry Lane, apartment 4B, you only need to write down 123 Huckleberry Lane. That's perfectly sufficient. The signature should be good. Upstate Jobs Party versus Zardy. This was a lawsuit out of Onondaga County. The Upstate Jobs Party, which is not a party, it's an independent body, had endorsed and nominated the candidate for county executive who was running on the Republican, Conservative, Independence, and I believe Libertarian Party lines, Ryan McMahon, who ended up winning the election. The election law for an office other than Senate, Assembly, or Governor requires that a candidate nominated by 2 or more parties and an independent body is required to merge that independent body in the same square as their existing parties. So As I recall, the situation here, the candidate was required to merge his Upstate Jobs Party nomination with his Independence Party nomination. The challenge came from the Upstate Jobs Party and the candidate and the Independence Party, saying that their rights were being violated, they were being forced to associate with another political party whose beliefs they didn't share. Fourth Department, however, said that it was perfectly fine to require this, that it was justified to prevent overcrowding on the ballot and to prevent the major parties from co-opting the ballot with proliferation of minor party lines. I certainly personally don't agree with that decision. I've never seen a situation where a major party has ever tried that, but needless to say, that is now the law of the land. Finally, on cases, some of you may have followed this in the news over the last month and a half. Another one I was involved in Supreme Court in Monroe County. The Republican State Committee chair and two voters in the 27th Congressional District brought a lawsuit against Governor Cuomo to compel him to call a special election for Congressional District 27, which has been vacant since October 1st when Congressman Collins resigned his office. The argument was quite simply that under the federal constitution, under the state constitution, the governor is required to call special elections to fill vacancies in public office. The result wasn't the one we were looking for. I'm not sure if it's accurate to say that we lost, but we certainly didn't win. The Attorney General, representing the governor, on our second court appearance stated that the governor had agreed to call the special election to fill Congressional District 27 on the 28th of April, and the judge found that sufficient. And the governor provided a letter that was sent to the Secretary of State saying that he intended to call the special election for the 28th of April. It's presidential primary day, if you recall. The judge was fine with that. Now, we still have not gotten a proclamation for an election on the 28th of April, but because of the 70 to 80 day window prior to the special election, that won't come, it shouldn't come until between the 9th of February and the 19th of February. From that point, of course, all the parties will have 10 days to make their nominations for candidates. It was certainly an unfortunate outcome for us, but if there's something that I think the folks here should take away, it's this, because from time to time, I'm sure you've all had vacancies in the Assembly, in the Senate, in Congress, in your counties, in your towns. There's pretty significant case law from the federal level and the state level that a governor is required to call a special election to fill vacancies in public office. The language that's been used is in the shortest practicable period of time. So leaving office vacant for 6, 7, 8 months, in my opinion, that's beyond practicable. But this is a tool that's out there if you ever run into a situation where you have a vacancy in the Assembly or you have a vacancy in the Senate or in Congress, and the governor is simply, for political purposes, sitting on his hands and not calling a special election. Something that has consumed a lot of my time and a lot of Ralph's time, and probably Jerry too, over the last year is the thinking about, talking about, worrying about the outcome of the Public Finance Commission. You probably saw, I think it was in late November, they put out their report, which under the language of the state budget took effect in December if the legislature did not take any action to modify or repeal. Right now, there are 3 lawsuits that have been commenced. The 2 in Niagara County, one, of course, the Conservative Party is involved with, the Families Party as well. And then I think it was 2 or 3 weeks ago, the SAM Party, the Serve America Movement Party, filed a federal lawsuit in the Southern District of New York, challenging the constitutionality of the Public Finance Commission report.
Joe, on this, I want to just, Ralph, come up here. I just want to, on this particular piece, since Ralph has been overseeing it with a firm, Woods Oviatt, that we hired out of Rochester, a very respected firm. Joe's been helping out with advice. We've been in court and we're anticipating a decision shortly. We're in court in early December. I'd like to just have Ralph, if you don't mind, comment a little bit, if that's okay, comment a little bit on this piece.
So as you know, we all anticipated that the commission that was established for the public financing of campaigns was going to eliminate or attempt to eliminate fusion voting. So we brought a lawsuit in conjunction actually with the Working Families Party. I sat with the Working Families Party. Jerry and I went to their union hall with pictures of Obama and pictures of Hillary Clinton in different languages all over the place. But in any event, we came to an agreement to bring these lawsuits. They took our advice to bring the lawsuit in Niagara County. In Niagara County, there happened to be 4 Supreme Court judges, all elected by fusion voting, all Republicans. So that's where we brought the lawsuit. We had the ability to bring the lawsuit where we wanted because we brought what's called the declaratory judgment lawsuit. So we brought that lawsuit in Niagara County, and the Attorney General, who would normally defend all of the several defendants that we have, initially recused herself. She recused herself because she had been brought along by the Working Families Party, who was obviously against the elimination of fusion voting. And so what then happened is all of the defendants got to pick high-priced law firms, downstate law firms, that all of us are paying for. So instead of the Attorney General defending the lawsuit, there are a number of large law firms that are defending each of the defendants. So we finally, we went through this process, and as you know, they went around the state, the commission, and they finally got to Buffalo October 29th. Jerry had brought up about the oath of office. Well, what about signing the oath of office? These people never, Jerry found out, these people never signed an oath of office or filed the oath of office, which we researched. Yes, the Constitution and the Public Officers Law says you have to do it. So on October 29th, when they came to Buffalo, I got up and spoke and said, look, all of you have no power here today because the Public Officers Law says since you haven't filed your oath of office within 30 days, your seat is vacated. So you are wasting all of our time. In response to that, the governor tweeted, the governor's spokesperson tweeted out that we're wrong, that there was a different section of the law that applied. He was wrong. That section only applied to disclosure statements. And in November 13th, they filed their oath of office. We still feel that's improper because since the seat is vacated 30 days later, you had to be reappointed. None of that happened. But as you know, instead of eliminating fusion voting, because I believe they realized our lawsuit was going to be successful. So I know you've got other people, but we've argued on 3 different strong legal bases that fusion voting couldn't be eliminated by this commission of unelected individuals. And I believe they understood that, And so what you saw was a second position that Cuomo still wanted to get rid of the Working Families Party, so they set up this 2%. You had to have every 2 years now, in the gubernatorial and the presidential election, you got to get 2% with a minimum of 130,000 votes. Well, the Working Families Party got 113,000 votes in the gubernatorial election, so they'd be gone. In fact, every party would be gone except us. So that, at first blush, looked like we won. Hey, look, they're getting rid of everybody but us. I don't feel comfortable with that. With a Republican Assembly, a Republican Senate, a Democratic Senate, a Democratic Assembly, and the governor, it was just a matter of time in my mind that he would still try to get rid of us down the line, only try to do it legally. So we still continued and pursued the lawsuit. We argued the lawsuit, and by the way, when they did that, here's how hypocritical that was. So they say we need to eliminate these parties because we only have $100 million, and too many parties, there could be too many individuals, and we wouldn't be able to do it within the $100 million. First of all, it's hypocritical because fusion voting is exactly the opposite. It's our ability to cross-endorse candidates. And secondly, they put the numbers in effect today, in 2020, even though public financing of campaigns won't happen until 2023. So the governor eliminated his requirement to be under public financing of campaigns because he runs in 2022. We have to have, if the law were to hold up, we have to have our 2%, and every party does, in this presidential election, even though it won't be till 2023 when public financing comes about. So at this point, we're waiting for a decision from the court. I would like to have come here and explain to you our success and our win, because I certainly believe it will come about. And at some point, hopefully I will be able to explain that to you at some point shortly in the near future.
Thank you. Anybody want to take it back?
Sure.
We'll get back.
Yeah, we're gonna, anybody have any questions for Joe? Good. Go ahead.
On when people were voting, they were signing in on tablets, electronic tablets, and there was no more paper registration. Is that something we could challenge? I don't see how you could audit that.
I guess I don't know what the argument would be. These are the electronic poll books that we now have because of early voting. I guess I just don't know what the argument might be as to
when we had those forms, they compared the signature of the last time you voted, and you signed in again. And that was a pretty good challenge in itself. But now I see people scribbling on a tablet, and there's nothing there. I don't know what happened to all the forms either.
I'd have to think about that. I can't really think of what the argument would be. I missed the paper, the hard copy too.
Yeah.
Hey, Joe, on the governor's proposal for the recounts. What can you tell us about that, and what is he likely to do that going to pass?
I gotta think. I don't know a lot about that other than what I saw in the press release. What I saw, I think he mentioned the state of the state possibly. Truthfully, I kind of anticipated that this was going to happen at some point or another. I mean, we did the changeover in 2010 to the new machines, and there's no provision in law for any recount. And I know that, I think they had one in Ulster County this year with the close TA's race, but that was because of a local rule. New York City's had a local rule, I think, for quite some time. It doesn't surprise me that he's trying to put forward something that's more uniform. And truthfully, it might not be the worst thing in the world. I think I prefer a standard in the statute rather than a patchwork of different local laws and different decisions from judges around the state. That also goes to which was developed in Essex County when somebody tried to foil the ballot images. Went to the Court of Appeals, of course, and they said that those were not foilable. There's a bill out there now. I don't know if it's, I don't think it's passed either house yet, but, and I know the Election Commissioners Association came out against it 2-1. But the proposal is to allow for ballot images to be provided a week after the election. Losers could cause, but of all the strange things that have happened in the state legislature, God only knows, it could become law.
Follow, anything new on the Broome County, the eighth race on that?
I haven't heard, yeah, there was another one where they were trying for a recount. I haven't heard where that's at, but I highly doubt you're going to get a court to order a recount simply out of being close. Now, if you had a provision in the law that said you get an automatic recount if it's within whatever, a tenth of a percent, then that'd be a different story and we'd all be aware of it. But yeah, I don't know what the latest is on that.
Joe, there was no injunction, right? The new DA is holding office, correct?
I think that's correct. I think that's
So there's a new DA as of January.
So actually, Jim would probably know better, but I think the one candidate was the first assistant DA, so he would be the DA anyway.
Any other question? Duffy?
Hi, hello, yes, Charlie Duffy from Westchester County. On the change of party, which is critical when we're approaching our reorganizations, is there any kind of time frame that the Board of Elections Commissioners have to issue the new voter roll out to parties? Because a lot of times what I've found is your relationship with the current commissioners can be stressed because we are one of the smaller parties. And you may or may not be able to get that information on a timely basis. How is the process of getting a valid new voter roll? Is there a time after the 14th?
Well, number one, up until the 14th of February, the changes of the roll take effect immediately.
Right.
As far as your commissioners then providing you, the Board of Elections in general, providing you an updated list, now maybe your experience is different than mine, but I've always found that you can go to one commissioner or the other and they'd be pretty helpful. But I think when you're looking for a voter list, it's really just a run-of-the-mill FOIL request if they want to treat it like that. So you're operating under those rules. Just your run-of-the-mill FOIL request, because that's essentially what you're doing.
Oh,
So,
we can take one more.
One or two more, please.
Yeah. I guess
I think in Hollywood,
Well,
Please stand up.
Go ahead, Duffy.
I guess my point being, if you go in on the 15th and they tell you, you know what, we haven't inputted all the changes yet, is there a time when they need to be able to say this is the certified roll?
There's a date when they have to publish, they have to tell you the numbers of what your petition signature requirements are. It's in February, I forget the date off the top of my head.
Okay.
But as far as getting a list, well, number one, the changes are supposed to take effect immediately. But number two, as far as getting a list, you're really just operating under your run-of-the-mill FOIL requirements.
Any other questions for Joe? The back?
Yeah, my question is regarding to the paid-for by on page of that I mentioned earlier. I just want to make sure I understood it correctly. So we're no longer required to put that on the graphics or the videos on social media or any digital platform, as long as it's on the landing page of those ads?
For the digital advertisements, you don't need to put paid for by as long as it will take you to a page that has that information on it. If it's too small to put it in.
Is that federal and state?
This is just state.
Just
This is state. Now, I wish I were well versed on the federal requirements, but I'm not.
Any other questions for Joe? All the way in the back.
Joe,
what is the time frame for filing and acceptance regarding NOTB?
I believe it's just like with your candidates, I believe it's 3 days. I tell you, take a look at the political calendar on the State Board of Elections website. That should have it on there.
Any other questions for Joe?